All right. Here we go. Test 3, question 1. The general rule is that anyone who knows anything about a crime is required to testify about it in court if properly subpoenaed. True or false? 2. The common thread uniting most common law and statutory privileges is the law's attempt to protect valuable social blank by ensuring that blank communications are not required to be disclosed in court. 3. With regard to common law testimonial privileges, Congress, when it drafted the Federal Rules of Evidence, did not include language describing each privilege, but relied instead on principles of the common law as they may be interpreted by courts in light of reason and experience. True or false? 4. Since the Federal Rules of Evidence were adopted in 1975, what is the only testimonial privilege which the United States Supreme Court has adopted in Jaffe versus Redmond, 1995? 5. Since the Federal Rules of Evidence were adopted in 1975, which is the only testimonial privilege which the United States Supreme Court has modified in Trammell versus the United States, 1980? 6. Besides the need to protect confidences within the relationships, for what other reason did the common law courts recognize the practicality of testimonial privileges involving priests, attorneys, and physicians? 7. What are the 2 different forms of marital testimonial privilege? 8. Which of these is universally recognized in all 50 states and the federal CJ system? 9. Which of these is considered obsolete and is dying out except in a handful of states? 10. Which is the oldest of the common law testimonial privileges? 11. Which of the common law testimonial privileges was first recognized in the courts in Ireland in the 1500s? 12. The power to protect his identity from being disclosed belongs to the confidential informant, aka snitch, and not to the government, which is duty-bound to protect the safety of its informants at all costs. True or false? 13. Under what exception to the attorney-client privilege may the government compel an attorney to testify against their client? 14. The attorney-client privilege protects from compelled disclosure blank blank between blank and blank made during blank blank. 6 words. 15. May a corporation claim the attorney-client privilege, yes or no? 16. Client charged with murder consults with attorney and discloses incriminating details. In the end, the client does not have enough money to retain a lawyer. May the attorney be compelled to testify at trial concerning what the defendant told him, since there never was an attorney-client relationship established, yes or no? 17. May an attorney who has been retained to represent a client charged with one crime disclose to the government his fear that the client may be about to commit another new crime, yes or no? 18. The doctor-patient testimonial privilege does not apply in criminal cases. True or false? 19. In the course of receiving psychotherapy, Michael Jackson tells Dr. Crazier that he has been molesting little boys for years. Later, Dr. Crazier is called to testify at Jackson's civil trial for molesting some of these children. May Jackson stop him from testifying, yes or no? Can Dr. Crazier be compelled by the government to testify in a criminal case against Jackson involving some of these children, yes or no? 20. Under the spousal incapacity testimonial privilege, defendant in a criminal trial may only prevent his wife from revealing confidential communications, but not prevent her from testifying about his conduct and other matters, true or false. 21, defendant is charged with murder in a state which recognizes a spousal incapacity testimonial privilege. He seeks to prevent his ex-wife from revealing confidential communications which occurred during their brief marriage. May she testify, yes or no? Assume the same trial is taking place in a state which recognizes only the confidential communications marital privilege. May the defendant prevent her testimony even though they are no longer married, yes or no? 22, under the spousal incapacity testimonial privilege, which applies in federal court, the spouse who is also a victim of a crime has sole discretion whether she wishes to testify, and the defendant's spouse can't do anything about it, true or false. 23, to whom does the attorney-client privilege belong? Attorney-client, circle 1. 24, the testimonial privilege for the news gatherer's source is based upon the freedom of the press protected by the First Amendment of the United States Bill of Rights, true or false? So that's 24. 25, what is the difference between the burden of proof, the burden of production, and the burden of persuasion? 27. At John's drug trafficking trial, the state calls Harry, a confidential informant, to the stand. Harry wants to give an alias and refused to give his address for fear of retaliation by the cartels. Can John force him to reveal his true address, yes or no? 28. May a presumption employed in a criminal case be conclusive, preventing the introduction of evidence to rebut it, yes or no? 29. Before the state in a criminal case may rely on a presumption, it must show that there is a blank blank between the proved fact and the presumed fact, and that's 2 words. 30. Defendant is charged with grand larceny for failing to return a rental car to Hertz. May the jury be instructed that if it finds that he failed to return it when it was due, they must presume he intended to steal it, yes or no? 31. What are the 2 categories of adjudicative facts of which a trial court may take judicial notice? 32. May a judge take judicial notice of the underlying principles and reliability of radar, yes or no? Of the underlying principles and reliability of the breath test for alcohol intoxication, yes or no? Of the underlying principle and the reliability of the polygraph machine, yes or no? That a person who has consumed alcohol may still form a criminal intent, yes or no? 33. Under what circumstances is a judge required to take judicial notice of a fact? 34. Name 2 of the 4 categories of witnesses who under the common law, by virtue of their status, were deemed always incompetent to testify in court. 35. Competency of a witness to testify is measured as of the time of the events being testified about and not as of the time of trial, true or false. 36. In some states, what type of convicted felon is still regarded as incompetent to testify in court under any circumstances? 37. Once a witness is testified under oath, may a court permit a party to impeach her by asking if she believes in God, yes or no? 38. In deciding whether to allow testimony of a mentally defective or very young witness, the court must answer 2 questions. Name 1. Can the witness appreciate the oath? And can the witness tell a coherent story? I forgot to put that on the board. So that's question 38. The questions are of any witness. But this is when you're dealing with a mentally defective or very young witness. Can the witness appreciate the oath and the consequences of lying? And can the witness tell a coherent story? Do they have the vocabulary to do that? So you guys will all remember that. Okay, so that's that one. I was almost done today, and then we had a bomb scare in the building. Name 2 of the 4 levels of impeachment of a witness's testimony. What are the 2 methods or procedures of impeachment of a witness's testimony? 3 of the 6 techniques of impeachment during cross-examination of a witness. Regarding which one of these techniques may you not introduce extrinsic evidence to impeach the witness's answers during cross-examination? What is the one thing you must do in cross-examination of a witness before you may introduce extrinsic evidence of a prior statement by that witness which is inconsistent with his trial testimony? Why is the hearsay rule no barrier to the use of a prior inconsistent statement to impeach the trial testimony of a witness other than the defendant? Extrinsic evidence is always admissible to show that any witness is a drunkard or a junkie, since this impeaches their psychiatric condition. True or false? Opinion and reputation testimony about a witness is only admissible to show whether the witness is truthful, but not concerning the witness's general morality or immorality. Give one of the 3 reasons usually given by judges who limit the introduction of extrinsic evidence for impeachment purposes under the collateral impeachment rule. Under Rule 608, what is the limit placed on an adverse party's introduction of opinion or reputation evidence about a witness's character? And that's probably all, but that's all I got anyway. So.
So how many questions are the teaser?
Not sure.
Oh, okay.
I didn't get finished.
It might be.
Oh, and there you go.